Court ruling relating to the National Assembly instituting impeachment proceedings against the President as the latest talking point leading us into the new year. Well, Chief Justice Mogoeng Mogoeng believes the majority judgment of the Constitutional Court that the National Assembly failed to hold President Jacob Zuma to account is a controversial matter and a case of judicial overreach. Well, Justice Mogoeng said that this in his minority judgment, in which he disagreed with the majority judgment read out by Justice Chris Jafta on Friday. To unpack the notion of judicial overreach, we are joined in studio by Professor Shadreck Gutto, Constitutional Law Analyst. Very good morning to you. Thank you very much for joining us this morning, Professor. You well?
Well, thank you very much, and to the viewers.
Firstly, take us through what the difference is between a court's minority and majority judgment.
Well, I think it is important for us to start by indicating that the use of the term impeachment is a term which applies in some jurisdictions, not in South Africa. South Africa's constitutional provisions provide for removal of the president, but also for a motion of no confidence. So there are two different sections. I think what the court was dealing with was really to interpret what removal of the president requires and whether Parliament had done its work. But if we want to focus basically on what we all watched on the TV,
yes,
where the Chief Justice gave a page to the Justice Party who was reading the judgment of the majority, it is rather unusual that that can happen. But at the same time, I think we have to put things in the broader context and see why the Chief Justice may have done what he did. It is not usual. Those are done in chambers or elsewhere. They are not done with people watching when a judgment is being passed, because the Chief Justice knows that a decision of the court is a decision of the majority. And once it is passed, it is binding. Therefore, you can't say, oh, but I have a dissenting opinion, as we call it in law, or a minority opinion. That doesn't matter whether it is read or not read. What matters is the majority judgment. So it was a bit unfortunate, but I can understand it because, you know, when the Chief Justice was being interviewed for the position of the Chief Justice, it was a very cruel process, which was very painful for him. And indeed, President Jacob Zuma appointed him the Chief Justice. So I think in this particular case, because the interpretation that a majority gave, which was correct in my view, is the one which will remove the president, and the president for having violated the Constitution and the law of the country and other provisions which are there. But it will mean that the president will have no benefits or anything thereafter. So it is a very difficult provision to apply it. But the Parliament failed, in my view, in its role, because I think what the court did was quite in line with Section 167 of the Constitution.
Why do you think that there was so much emphasis placed on the fact that the decision was not unanimous and that there was a minority and there was a majority?
That is very normal. In law, judgments of the court are not usually one which is unanimous. A lot of judgments which we use, which we call and so on, they normally a minority opinion or judgment by a section of the court. But what is important is what is binding, which is the majority decision. We have had a lot of cases where there are minority opinions by the judges. So it is not the first time, and it will not be the first time. Yeah.
Now back to the crux of this ruling. The justices were split as a result of Chief Justice believing that there were reasons to believe that there was possible judicial overreach. In the most simplest terms, describe to us essentially what is judicial overreach, the boundaries, the limitations.
In my view, separation of powers is a concept which says that government has three branches: the parliament, executive, and the judiciary. That's a very simplistic way of explaining it. The role of the judiciary is very important because the executive drafts laws and presents it to parliament. Parliament polishes it and passes it. So, and then it is up to the executive to implement the laws after decisions have been made where there's a dispute by the court. So the courts are the only, is the only institution rather that interprets the law. There's no other branch that can interpret the law. What the court did indicate here is that Parliament has failed to be able to adopt rules which it can use to be able to deal with situation where the executive is actually undermining the constitution and the laws of the country or breaking them. Parliament can be able to remove the chief executive, the president, but it cannot do so when the rules are not in place. So it is the failure of Parliament to be able to adopt appropriate rules. And that is not the only area where Parliament has failed, in my view. There are a lot of areas, even Section 25 of the Constitution, where people talk about land reform and so on. There are strict provisions which say that those who are denied security of tenure, which is legal, ought to be given legal security of tenure. That's the people in the former homeland and so on. They still don't have a law which really can help them to have legal security of tenure on the land. There are other provisions like Section 180 which says that a law ought to be passed which helps to ensure that people who are not just the judiciary or the judges can also participate in making decisions about interpretation of the law in the country. We don't have anything like that. So I think there are a lot of areas where Parliament, and in this case the National Assembly, has failed to do its work. And this particular case is going to open up so that we begin to ask Parliament to do its work properly and to do it quickly. But also the court, mind you, went ahead, the Constitutional Court, to say the cost of legal representation in this matter ought to be borne by the parties, and they ought to do it individually. And I think that is another area which is going to be very difficult for President Jacob Zuma, because it is very expensive to take a matter to the Constitutional Court. The lawyers who argue there, the charges they make are in thousands and thousands per day, and it is very expensive. And what they're saying is that there's abuse of public money, of taking matters to court all the time, because the people who are doing it are actually not paying from their own pocket. And I think that that's another area which this court brings out.
Now, what are some of the mechanisms, in your view, that need to be put in place to circumvent judicial overreach? I don't think that there was a judicial overreach. But Justice
I don't agree with the Chief Justice.
So you disagree. Why do you disagree, Professor?
I disagree because that's the role of the court. If the court is not able to carry out its functions, particularly the Constitutional Court, under Section 167 of the Constitution, I think it is 167(4)(e), then the court will be itself undermining the role of the judiciary. So to be able to say it was an overreach, I think the Chief Justice was really overreaching, or rather putting, if you like, problems that will confuse the public. What one could say is that the decision of the court, particularly Section 2 of the Constitution, the decisions of the courts are binding. And that is also a very important section. But the court went ahead to say that the National Assembly failed in its role under Section 237 of the Constitution, which says any institution that performs a constitutional role or legal role has to do so diligently and to do it without delay. There's been no diligence on the part of the National Assembly in trying to see, we are empowered to do this. Do we have the rules, proper rules that will make us do it? So I think Section 237 was also strongly emphasized in the decision of the majority of the courts.
Now let's go back to the whole notion of impeachment, specifically here in South Africa. It's more of a foreign concept. Is it something that could actually exist?
It exists in many constitutions in the world, whether they call it impeachment or whether you call it removal under our Section 89 of the Constitution, or you call it having a motion of no confidence, which is Section 102 of the Constitution. Whatever it is something which ought to be there to ensure that the leaders of the country, particularly the presidents and prime ministers and so on, cannot simply continue to be in office when they do not themselves really act according to the Constitution and the laws of the country. Otherwise, you don't have a rule of law.
Yeah. Now, in having a look at how the court judgment and the court ruling played out, what are your forecasts for the coming new year and the dynamics that we could possibly see in the National Assembly and Parliament?
Parliament should wake up, not just the National Assembly, even though this was applicable to the National Assembly. But we have a parliament which is made up of the National Assembly and the National Council of Provinces. The whole of the parliament need to wake up to look at the Constitution properly, see areas where they have not been able to put proper rules on the ground. But it doesn't mean that any rule that they put there will be found to be constitutionally valid, because even those rules can be tested in a court of law to see their constitutionality. And that's the role of the High Court, Supreme Court of Appeal, and Constitutional Court ultimately.
Definitely. Thank you so much for joining us in studio. That was Professor Shadreck Gutto, Constitutional Law Analyst. Always good having you in studio and explaining things in a language that we can understand. Thank you very much for your time this morning.
Thank you very much, and I wish everyone a Happy New Year.
Thank you very much, Professor.
Great.